In this module, we will cover the subject of the European Convention on Human Rights, also known as the ECHR, or the Convention. The European Convention on Human Rights is an international treaty created in 1950. The Convention sets out a series of basic rights in Articles 2 to 14, as well as in some additional protocols, which all contracting states agree to secure to everyone within their jurisdiction. The Convention also created a European Court of Human Rights, based in Strasbourg, as we saw in the previous module, to decide whether states have breached the rights of individuals. The European Convention is drafted in broad terms in a similar, albeit more modern manner, to the English Bill of Rights, the American Bill of Rights, the French Declaration of the Rights of Man, or the first part of a German basic law. Statements and principles are from a legal point of view, not determinative, and require extensive interpretation by courts to bring out their meaning, in particular factual situations. The Convention consists of 3 parts. The main rights and freedoms are contained in Section 1, which consists of Articles 2 to 18. Section 2, Articles 19 to 51, sets up the court and its rules of operation, while Section 3 contains various concluding provisions. Let us summarise the main rights protected in Articles 2 to 18 of the Convention. Article 2 of the Convention protects the right of every person to their life, save in the case of lawful executions. The second paragraph of Article 2 provides that death resulting from defending oneself or others, arresting a suspect or fugitive, or suppressing riots or insurrections will not contravene the article when the use of force involved is no more than absolutely necessary. The court has ruled that states have 3 main duties under Article 2. 1. A duty to refrain from unlawful killing. 2. A duty to investigate suspicious deaths. And 3. In certain circumstances, a positive duty to prevent foreseeable loss of life.